Okay, so the next session, and continuing on the same theme, is the following very interesting topic. Desperate measures in desperate times, the last resort arguments and approaches to rescue an international construction claim. This session will explore the arguments by which otherwise doomed claims may be successfully advanced. Against the backdrop of the pandemic, the panel will discuss the issues and restrictions which might stand in the way of an international construction claim and the innovative approaches by which these obstacles might be overcome. Leading this discussion is Kwadwo Sarkodie. Kwadwo is a partner in the construction and engineering and international arbitration groups of Mayer Brown International. He has extensive experience across a broad range of dispute resolution methods. His wide-ranging international experience includes advising in relation to projects and disputes in sub-Saharan Africa, Latin America, India, and the Middle East. He regularly advises in relation to arbitrations, including under the ICC, UNCITRAL, and LCAA rules. Paul will be very pleased. And has written extensively regarding arbitration in sub-Saharan Africa. He also regularly acts for both contractors and employers in relation to disputes under a wide variety of forms of construction contract. He has extensive experience with regard to litigation, mediation, and adjudication. Over to you.
Thank you very much indeed, James, for that kind introduction. And continuing the theme of introductions, joining me today for this panel are Kate Corby of Baker McKenzie, who Legal 500 praises for her strategic thinking and describes her as excellent, smart, focused, and very adaptable. And I think they serve to highlight just how well placed she is to be addressing some of the issues we'll be tackling on this panel as a very highly experienced partner with a wide range of experience in all manner of construction and international arbitration disputes across a very broad geographical range, including Kazakhstan, Panama, right across the Middle East, which she augments with a further specialism in relation to product liability issues and multi-jurisdictional product recalls, a field in which she is an acknowledged expert. Also joining me will be Nicholas Gould, partner at Fenwick Elliott, listed by the IBA's Who's Who of Business Lawyers today as one of the 10 most highly regarded individuals internationally for construction law. Nicholas's particular expertise in relation to complex, high-value disputes around the world cover a number of technically complex construction sectors, which include energy, infrastructure, rail and metro, communications, and a host of others. Nicholas also has a particular profile in the power sector with experience in relation to a broad range of power generation projects. Nicholas is also duly qualified. I understand, Nicholas, you're also a chartered surveyor. And in addition to being a vice president of the ICC's Arbitration Commission, Nicholas is also a visiting professor here at King's College London, and so may be familiar to many of you here with us today. Third, I would like to introduce Marion Smith QC of 39 Essex Chambers. Once again, selected for extensive construction experience. It includes working with and advising clients at all levels of the industry in relation to a broad range of sectors, including bridges and roads, housing and retail, hotels and leisure, hospitals, rail, to list but a few. And this sits alongside extensive experience in relation to international arbitration and professional negligence disputes. Marion has also been involved in a broad range of disputes concerning both standard form and bespoke contracts, which is coupled with in-depth experience in relation to PPP and PFI contracts. Chambers and Partners' description of Marion as forceful and providing clear and concise advice with a no-nonsense approach, and Legal 500's confirmation that Marion is recommended for large-scale construction disputes serve to underline how well-placed she is to opine on the matters that this panel will be addressing. Now, on that subject, it has always been the case that the world of international construction law and international construction projects more generally are characterised by complexity and risk. However, what we've seen in recent years are a number of unique factors and unique pressures, which, aside from transforming our lives in many ways, have of course had a significant impact on international construction projects. I'm of course talking about the COVID-19 pandemic and its many consequences. The mere fact of how unusual it feels to be sat here, not socially distanced from my fellow speakers and sharing a room with all of you, just serves to underline quite how dramatically our lives have been impacted and changed over these past 18 months. Now, in relation to international construction projects, the dramatic changes brought about by the pandemic have been reflected in and accompanied by impacts such as material shortages, supply chain bottlenecks, new and restrictive legislation and regulations, sometimes introduced at very short notice, restrictions on the availability of labour and skills, etc., each of which have the potential to profoundly impact the viability, economics, practicalities, and so on when it comes to delivering a large engineering project. Add to this too the impact of factors such as Brexit, commodities prices fluctuations, and it's clear we are living in a particularly turbulent time where risk and threat abounds. And it is in times such as these, which may be desperate times for a project which has been impacted by these factors, that contractors, subcontractors, or construction professionals, as the case may find what begun as promising and profitable contracts and relationships have been transformed. Cost overruns, terminations and the like may leave claims and disputes as, however, unpalatable, the only practical route forward. And indeed, the successful pursuit of a claim may be critical to survival. However, when this stage is reached, a whole host of further challenges and obstacles may present themselves, and that is what we'll be exploring with the panel in this afternoon's session. This serves to bring into focus some of the issues that will be explored and navigated, with insights with regard to how best to address and avoid these issues and obstacles which may, if not handled correctly, serve to block the successful prosecution and recovery of a claim. So I'm being very fortunate today in being joined by a panel which collectively boasts decades of experience in handling some of the most complex issues and matters with regard to construction disputes, and as such are ideally placed to share their wisdom from across the construction industry and with insights from a range of jurisdictions, legal backgrounds and perspectives with regard to how best entitlements and claims which may first appear doomed can in fact successfully be pursued. So Kate, if I might begin with you, would you be able to share with myself and with the audience here some of your observations and experience in relation to the specific challenge posed by deficiencies in contemporaneous evidence and records with regard to causation and the like?
Absolutely. So as you said, I'm going to start off ease us in talking about a practical issue, and I'll leave the law to these guys here to follow on with. So over my career, I think it's fair to say a frequently seen obstacle to successful claims has been problems related to contemporaneous evidence, or more often the lack of it. So sometimes it's lack of evidence per se. So I'm sure we've all seen instances where there's been a failure to update the programme during the contract or during the execution of the project. There's been a failure to compile periodic reports, or they just randomly stop in the middle of a project. Important letters that haven't been responded to, and a failure to keep records of manpower, so where people were working, or in the cases of an idle labour claim where they weren't working and why they weren't working there. This obviously causes problems both from for the lawyers to particularise the claim, but also particularly for the expert witnesses who need to be backing up the claim. Slightly different scenario is not lack of evidence per se, but difficulties or deficiencies in the evidence itself. So conflicting evidence, obviously different parties writing contemporaneously have a different view on how a project is progressing. Or evidence, and this is a particular difficulty that exists, but doesn't deal with causation. So lots of, and I'll come to this with a particular example where there's lots of people complaining about delay, but not actually saying what the impact of that was. So I cast my mind back to what was the best project to illustrate that I've been involved in to illustrate some of these topics. And it takes me back to a dispute between two joint venture partners who are part of a group of companies acting as contractor on a construction project in the Middle East. And for today's purposes, the key clause entitled that where one joint venture partner's activities, where their scope of work had caused another joint venture party's scope of work, the cost to increase, then the first joint venture partner was liable. So obviously the key word there is caused. Now, there were all sorts of problems on this project. The project manager wasn't regularly updating the programme. So each joint venture partner had their own different records of progress. You can probably guess where I'm going to get to here. Each side instructed delay experts. They each created from scratch, from all the different plethora of sources available, as-built programme. They were different. So that's not a great place to be starting from. There were inconsistencies. There were several different types of progress reports that had been prepared on a monthly basis. There was one which the joint venture sent to the employer. There was an internal one just for the eyes of the joint venture partners, and our client was sending one to its head office. They all had different progress percentages. Sometimes the progress percentages went up and then they went back down for a particular item of work. Perhaps most impactfully, while tens of thousands of letters had been written over the course of this project, it was very difficult to find any letters which actually linked delays on this for the civil contractor that were causing, what impact that was causing for the process contractor. They weren't saying, we are ready, we've got these people waiting on site, we haven't been able to use them today, tomorrow, whatever, we've had to pay extra storage charges, all those kind of things. And because the clause was quite specific and it said cause the other party to incur additional costs, it was very difficult. I think that the best analogy to use to describe what we had to do was we were trying to build a jigsaw picture for the tribunal, but we were having to use pieces from different jigsaws that just about fitted together and just about gave a picture at the end. It's also arisen much more recently in the context of the pandemic in relation to situations where we've been advising clients on force majeure issues, either claims that they've been wanting to make or that they've received from other parties on their projects. And I've lost count of the number of times we've had to explain to clients, you can't just say pandemic equals force majeure. You need to be able to say, what is the specific change in law that has impacted you? How has it impacted you? Why can you, if you can't bring your expats in anymore, why can't you just use people in the country? Why can't you use wood from the forests in the country? All the supply chain issues. And really that causative link, I think when you're looking at a project that's kind of still ongoing at the moment, you can rescue things a bit more easily than we're often very used to dealing with projects where the problems happened 5+ years ago, and it's very difficult to go back. So what can you do, and what have I seen be done here? So the first thing is to work, as we had to do on the case I talked about, work extremely closely with our client and the experts to go through all the evidence that was available. What could we patch together? What bits made the most sense to create this jigsaw puzzle picture from different, I think, and then secondly, and this is what we've been doing with the force majeure claims, where they've happened much more recently, what can you get from third-party sources? What can you go back and what can you get created now, which is kind of semi-contemporaneous? Because it may be that these disputes don't get heard by a tribunal for another 2 or 3 years, by which point it will be too late. And what can you, as I said, what can you get from third-party sources? Another approach, and I'm taking this on a particular case at the moment, which the case, the project's been going on for a best part of a decade, where one party puts forward a set of evidence that on its face looks okay. The other party doesn't have the best evidence, but doesn't have their own opposing evidence that they can put in. So really kind of start at the bottom, knocking holes. What holes can you knock so that eventually the whole edifice will fall down? Because it's very easy, I think, when you think back to people writing these reports and letters when in the midst of the project and not thinking about how they might be used. And I think, and this is not that helpful for where the lack of evidence is already crystallised, but I think probably most importantly in the long run, and this is something that I talk about a lot, is making sure that lessons where we work regularly with the same clients, making sure that the lessons have been learned from past difficulties. The old adage, prevention is better than cure, is absolutely vital. So at the start of any new project, making sure that there is an agreed plan, process for document creation. So not just, yes, we'll have monthly reports, but what documents are going to be created? Who's responsible for doing them? What's the minimum content? What do you say if you issue your minutes for approval and nobody comes back to you? Are they deemed accepted after a certain period of time? And then monitoring things as it goes on. I mean, it's kind of basic elements of effective contract management, which having spent the best part of 20 years in doing these types of claims still surprises me, and I guess I wouldn't be in a job if it was more effective. But really coming back to that and really trying to stop these issues, or you're getting into this practical difficulty in the first place.
Thank you very much. That's extremely interesting. And I was particularly interested to hear about some of the steps you described towards the end about how perhaps some of these issues might be avoided and addressed. I mean, do you have any examples from projects that you could describe where you've seen this work well?
Yes, absolutely. So when I talk about effective contract management, what we're really talking here is it goes through the whole kind of the project, the life of the project, and actually it starts before the project gets underway. So making sure that the contract that is being entered into is suitable, because we all know what happens. People tend to use the contract they worked on the previous project, recycle it, you try to use it again. And is it actually suitable? What are the commercial, or do the contract terms reflect the commercial reality? Because often we find that they don't, which leads then into the kind of understanding the deal that's gone on the project. What is on this particular project, where were the risks? Who agreed to shoulder which of the risks? Something we often work with our front end colleagues is once they've signed all the project documents, having a handover meeting with some neutrals like us, able to talk through flowcharts of how the contracts, how the conditions precedent, which I know is going to, notice provisions are going to be talked about later. How do they work in this particular project? And then following that through with regular health checks. So there's one particular project we've been involved in. We've resolved all the issues now. It was a kind of high-tech skyscraper project. It was let in a slightly unusual way in that, in effect, every floor was let as a separate contract, and then things like the lift shaft was let as another separate contract. I think to get some kind of competition going, but actually our client ended up being the contractor for every single one of them. So there was a lot of repeat issues coming up, and it was an employer-friendly contract. There was I have to say, pretty biased contract administrator. Nothing passed muster with them. We became involved, and when we became involved, it was pretty clear that our client was being fobbed off. They were just giving in. They weren't really, but also partly because they weren't substantiating their claims properly. So we kind of went back to basics. We talked with them through what did the contract provide. Yes, they didn't have many rights, but they did have some rights, and they needed to work out a way to get them respected. We talked about what paperwork they needed to create for each of these claims to lay the groundwork try to get them resolved individually, but also if there was going to be an arbitration. We then checked in regularly with them, reviewed the evidence, made sure they weren't just pushing everything off to that later day, which then never comes. And actually, because it was the way that the contract was let, these issues were coming up again and again. And actually, they got into quite a good habit of doing this. And we managed to resolve a number of issues. We pushed even issues that arose when one of the major subcontractors went bust. We'd got into a habit. The employer knew our client wasn't going to be a pushover anymore. And it really resolved those issues on a case-by-case basis before we never had an arbitration, which for the client was a result.
Fantastic. Thank you very much, Kate. And one interesting thing you mentioned was conditions precedent. And Nicholas, it'd be interesting to hear from you how these potentially can pose a particular challenge, particularly in the sort of desperate circumstances that we're looking at here, where perhaps they haven't all been complied with fully in due time during the course of the project. Are you able to share some of your views and experience in relation both to how these operate and what a claiming party might do if the time has passed, or at least could be argued to have passed, and a condition has not been complied with?
Okay, yeah, so let's have a look at those, and I'm conscious of the time, so I'll keep it as brief as I can. The interesting thing about these conditions precedents or time bar clauses is that when I first started working in the industry, they didn't exist. I think, I suppose for those of us that remember the NEC coming out in 1993, 94, that's the first time we saw them in relation to compensation events. But in the international arena, it wasn't until 98 when you saw the FIDIC draft, and then in 99 the new FIDIC contract came in with this clause 20.1, that we really started to see them. And I don't think the industry paid that much attention to them because we were so used to, dare I say, not serving notices. And we had this old English case of where you ask the question whether they're mandatory or directory, where they're just directory. It's convenient if you've got one, but well, never mind. If you've got a claim, you've got a right. And this, I think, is the real shock about these provisions, is that they work. And there was a period where perhaps people thought, well, the prevention principle would save us. How can it be that if the employer issues a huge variation and the contractor's got a claim for time and money, but they haven't served a piece of paper, they lose their rights to weeks, months, millions. And of course, I don't know if for any of you that may have remembered the case of Multiplex and Honeywell 2007 case, which made it very clear that these work and the prevention principles got no place, because it's not the employer's fault that you, the contractor, haven't bothered to serve one piece of paper. I do recall, this was a case we were involved in, I do recall Rupert Jackson, that was a judge in that case, saying, how can it be that we have an industry filled with people with degrees and masters and professional qualifications that can't send a letter that says, I think I'm going to be late. And actually, in that context, you do start to think, well, it's got a point. And actually, if we were, though, I want to do two things really. Now, one is just have a look at FIDIC briefly and then give an example. So if you were to look at the FIDIC clause, first of all, the language needs to be very clear. There needs to be a trigger date, some time passing, and then a right that you lose. And this is actually very clearly done in FIDIC. It's not an option, because you do find yourself looking at bespoke provisions and thinking, was it just an option to issue this, or is it really mandatory? And of course, the wording in FIDIC clause 20.1, for those of you that know, or maybe those of you want to have a look, is the contractor shall give notice. I'm going to the 1999. It was only the contractor that was doing this. In 2007, it's the employer and the contractor. So it applies both ways. I'm sure we're going to see amendments. Maybe it will just be the contractor. Only keep an eye for the amendments. But then it goes on to say not later than 28 days after the contractor becoming aware or should have become aware of the event or circumstance. Now, this is where we get into all the exciting issues that we see every day and we've been seeing for 20 years. Let's take a large project, 3 years long, unforeseen ground conditions. They're obviously going to be happening at the start of the project. Maybe the activity schedule shows that six months worth of ground working, and in month 3 there is a problem with rock in the ground, say, and the contractor's notice doesn't come along for several more months. The obvious response always from engineer employer is, you're too late, you're out of time. But of course the question you've got to ask yourself is, well, when did the contractor become aware, not of the fact that there was rocks in the ground and the chap driving the JCB noticed this on a Wednesday, but when did the person with sufficient authority know about it? And that's the first thing. There's an interesting old case, Denning, as he was, in Bolton and Graham, 1957. The directors and the managers represent the controlling minds and the will of the company, not everybody else. And Law Reed in Tesco and Nattrass, 1972 case. Sorry, I'm talking about English law for the international crowd there. Normally, it's the board of directors, the managing director, and perhaps senior officials that are the minds and the management of the company. And so it's often these claims are rejected out of hand early on, when we need to be asking who is it that needs to identify not just the event, but when it actually has an impact on time and money. Because in the first few months of a project that's 3 years long, the only obligation on the contractor is to start on time and finish on time, and how they get there is pretty much up to them, and the programme's indicative. So you know, from the word go, you start to get into this whole question about when they should notify. And we have so many arguments about these still in arbitrations all the time. And I'll just one more thought before I go on from that is the other one is where there's no notices at all. This happens all the time, and several examples there of where the contractor's been told, I don't want any more of these sorts of notices after one's been fired off. And frequently witness statements will prevail in an arbitration in that situation.
Thank you very much, Nicholas. So if I could now turn to you, Marion, while we still have some time. As what Nicholas described is very much dependent on the contract, but do you have a few more observations around that subject and around what's covered?
I do. Desperate measures, desperate times. I have two ideas to share with you. Read the contract, and what about estoppel and good faith? Let me take the first one, read the contract. It never fails to amaze me how often that hasn't been done. And you just simply start by gathering the contract together, all 5,000 pages, spreadsheets, CDs, additional reports. You may then find that, in fact, that schedule you thought was missing, as we have found out in one case, it wasn't missing, it had never been agreed. I found in life that men who wear anoraks do not produce schedules. Do not let them go and produce a software schedule, setting out the KPIs, they'll never do it. Then you've got to discover, how do you change the contract? Get to know the contract mechanism, which is what Kate was talking about, because they will have changed it. Have they changed it validly or invalidly? You need to know that. Why do I say all of this? I say it because it will give you wriggle room. We have very clear rules now under English law about contract interpretation. We know how important the written word is, but we also know that there is flexibility. There's flexibility for two reasons. Somewhere down in the boilerplate, that deep, dark place where no one goes, there will be some risk allocation devices, entire agreement clauses, no oral variation clauses, precedent clauses. They can be your friend. Find them. There's also wriggle room. Let me explain to you why. Let me ask you three questions. The first one, what's the average reading age in England and Wales? Just think about that. It's 9 years old. What is the maximum number of words in a sentence for you to remain under control of the meaning? Between 15 and 20 words. People don't read, they scan. When you look at that, you're not reading it word by word, you're scanning it. How much do you scan of a page? Could anyone read? 25%. So to answer Lord Justice Jackson's question, why can't people write letters? Just remember this, the contract, the letter writer is probably with an average reading age of 9, writing sentences that they have well lost control of in a document that they will have read 25% of. That's why you read the contract. My next point is estoppel and good faith. When I started, and I'm not going to tell you when, I can remember making my opening for the first time, and I said very brightly to a very old, very wise arbitrator that I was about to make my opening on the law of estoppel. And I paused because I'd lost control of my papers. I couldn't find the part I wanted. And so he, to help me out, said, don't worry, my dear. I was still in the age when you could say my dear. He said, when I came to the bar, it was always the last resort of the forensically destitute. But take your course. But it isn't that any longer. And I'm going to get the right words. It is now seen as being the safeguard against injustice. That's what Lord Sumption said in the Rock Advertising and NWB case dealing with no oral variation clauses. A safeguard against injustice. And I'd be interested to find out if you all agree with me, but I think any tribunal wants to achieve a just result. And your task is, of course, is to present the evidence, to present the arguments, to tell them why your case is the just case. And then you have to give them the hook on which they can peg that result they want. And estoppel will do it. There's a range of doctrines. It's not completely the Wild West. There are some clear parameters, but it has a flexibility, and a good arbitrator, a good judge, a good adjudicator knows how to get that balance between certainty and justice right. Good faith, I almost whispered it. I think given the time, that's all I'll say. Don't forget it. It's there in the contract, it's drafted into many standard forms, and you're out of kilter with the times if you think it is bound to be given no meaning. That's all.
Thank you ever so much, Marion. So I wonder if we have time for a few questions, James, from the audience.
We do. I'm looking hopefully to the in-person audience. 2 hands, excellent. At the top, first of all, name and question, please. You're going to have to speak up, Sean. Yep. So, Sean Gibbs, could the panel please comment on estoppel by convention? Well, in what respect, Sean? using it as a tool to dig yourself anyway.
It's underused, Sean. In my book, it's definitely underused. I find it's one of the most profitable lines. It's certainly underdeveloped legally, which may help. So I think it's something to be getting out there and using. It's also one that the no oral variation clause won't bite on. So, well, usually won't bite on unless it's particularly well drafted, and it may also escape the entire agreement clause. So, yep, go for it. Any more specific advice, see me afterwards.
Question here, I think.
Often so can you explain back to me?
Can good faith be used to plug the hole of a lost argument, or is it? Sorry. To rescue a claim, or is it merely persuasive?
Well, rescuing claims is what we're all about. Nicholas, could you take this one?
Sure. I think sometimes it helps a lot, but when you start to look at many civil law countries on the international arena, you find you're bound by the words on the page, and if it's very clear they're not going to depart from it, how have the parties actually operated the clause, you might end up in a similar place. But if you look at, for example, the UAE Civil Code, Article 106, which is the disproportionate harm provision, I haven't served a piece of paper, but I don't get a claim for 10 million. That has much more teeth, I find. And is accepted much more. So I think when you leave this common law approach that we're sort of looking at, and you enter this area, look very carefully at the applicable law in that country and see how it operates, because you might find you're in a different regime. Forget Rupert Jackson, if I dare say that to this, and multiplex and all of that, but start to look at how really. And there is a terrible tendency, if you end up with international lawyers, sometimes in a totally different country where there isn't much law on the subject, just thinking like English lawyers or American lawyers or whatever they are. Put that to one side and have a proper look at the local code and work with local lawyers to think about it. But disproportionate harm, I think, is underused.
It's tempting to swerve onto good faith in context of relational contracts, but I won't do that. An online question, an anonymous question, which I think is a very good one. Surprisingly, contract management is not highly promoted in many organisations. And in most cases, the day-to-day contract administration where issues can be prevented are performed on-site by engineers, not necessarily with extensive legal background. What are your views and recommendations to bridge this gap? And I think that touches on one of the issues which is central in my mind in most projects, which is the project team on the one hand and the legal in-house team on the other. any comments?
Yeah, very interesting question, and I think, Kate, that touches on some of the points you were raising, and I wonder if you had any further observations on it.
So I think that's absolutely right. And one of the things we've done over the years is work with some of our big contractor clients who have, over the last few years, set up a contract management expert function, who are gathering together and training contract managers who can then be responsible for a particular region or a particularly large project, and who go out. They don't have to be there, based there every day on site, and actually can help with that little bit of distance, going out and regularly checking what's been going on, what documentation is being created, what are the issues that they could take away and try to resolve. But I absolutely agree with the question that it's definitely underused, but is something that everybody involved in the industry needs to be trying to promote as a practical way to avoid disputes in the first place.
Okay, a couple more questions here. What prospect does restitution or unjust enrichment have as a last resort where the contract is against you?
Thank you. And so, Marion, I'd be interested to.
I'm shaking my head.
I'm not sure if that was a genuine thanks.
If you've got a contract, you're going to be very, very limited in the scope of a restitutionary remedy. But never say die. Put it in there. Just allocate your time in submission appropriately. My view. Do you agree?
Yes. Unfortunately.
Yeah.
All right. More questions still from online. I'm looking again, hopefully, into the in-person delegation. But next question from online. If there is a delay event that is continuing and more information on the delay impact comes to light over time, changing or developing more contractual bases of the claim, how does the time bar apply? You set yourself up for this with the topic. You're getting difficult questions.
You could.
I say the fun of it. You know, when I think people drafted these clauses, they were thinking, "Oh, there's going to be one nice event, and then off we go." That's not reality at all, is it? You have something happens, it doesn't affect time, and then later on it does because you've started to think about it properly, and it keeps changing. FIDIC tried to grapple with this a bit in the 2017 by wanting interim applications and interim submissions to be made. But you know, example-wise, I can think of circumstances where a notice has been given, months have gone by, claims have gone in about it, other things have happened and some more notices have been given. If you look at it very carefully, you find you've got some notices about most of it, but actually not notices about everything, and claims about all of it and more. In most of those scenarios, because the other parties answered it all, you're into a quite nice waiver situation about all of that. But if you start, you know, to pick it apart, we unfortunately are entering a world of having disputes about disputes. We don't really want to look at what time should be given or what money should be given fairly. We just want to argue for 3 years about whether you served a right notice. Now that's fun for the lawyers and we enjoy it, picking it apart. But I do feel the industry's got itself into a bit of an unfortunate position. I would take time bar notices out. That doesn't mean to say I always have contractors, but I think something is needed in order to manage time and cost properly. But I do think that when we get to the end of projects, we spend too much time arguing about whether there were notices and so on and so forth. The NEC type emphasis of dealing with disputes and time and money as you go is kind of the emphasis we need to get onto all projects. That's not a contractual one, is it? That's just good management. Do we need a contract to persuade people to do that? Not really. You can do it under the old JCT if you manage looking forward your sort of costs and time every month and face the elephant in the room, as it were. You know, I think it's very easy on some of these big projects to go for years and years without anyone talking about the big disaster or what's really causing delay. They're too worried about the good things that are happening, and no one wants to actually face up to the real problem. But that's just a management problem, not a legal one.
And human nature.
Okay. Final question then, and this is from Julia Bueno in Brazil, and stems from a question I asked earlier about the project team on the one hand and the legal team on the other. How do we prepare the technical team to understand the importance of preparing evidence for potential good faith or estoppel arguments? Are there any specific recommendations for project managers, contract managers who are in the middle of a big project and they've got to be thinking about these difficult legal questions? What can they do practically?
Could you take this, and then perhaps Marion, you could chime in with a couple of observations as well?
Yeah, I mean, I guess I would say if you're already in the middle of the project, it might well be too late. Where it works really well is doing it before the project starts. So making sure that the team on site have flowcharts. You can do flowcharts, you can do back to basics about the type of evidence. I said earlier, have a process in place that deals with what records, who's responsible for them, how frequently, what they should contain, have templates that get filled in. But then I think it's very important to have somebody perhaps from head office or from regional management who comes periodically and asks, because it's all well and good having a process set up, but when things get hectic on site, they get forgotten. I'm a big believer in kind of processes and planning things in advance. Plan for the worst and you experience the best, hopefully.
And the only thing I'd add to that, I'm going to go back to my 9-year-old. People get intimidated about keeping records. We say it all the time. But there is just this bar, picking up the pen, typing out. I would just dumb it down and get over the message. Send yourself an email. Put it in a WhatsApp. Just get it somewhere permanent and then leave it to your management and to your lawyers to come in and sort of gather all that information. But you've got to have the contemporaneous record.
All right, well, we're out of time now. We're now going to break until 3:40. The online audience, please remain logged in if you wish, or you can log back in later. We didn't have enough time to cover all of the questions that you very kindly put to the panel. So if you'd like to ask the questions, I'm very sure they'd be pleased to receive them via email after this conference. But for now, please join me in thanking Kwadwo, Kate, Nicholas and Marion.